Welcome to another episode of Legal for Tech, the podcast. So, as I said many times, it's Rosie here, and we're just a group of friends, of students, and young professionals who are just interested in anything that has to do with the regulation of the tech sector. And I have to say that today is a particularly special day because we have a very esteemed guest, Dr. Selina Zipponi, who is a very prepared DPO, but also she was very much wanted by one of my colleagues here, Giacomo, who will then tell you why he's particularly interested in this guest, because she is also the author of one very useful book. This book is, for now, just published in Italian. So, for all our Italian listeners, I will tell you the title in Italian. It is Privacy Extra UE, guida alla protezione dei dati per le imprese che operano all'estero. And as a preview for all of our international listeners, I will give you the title in English. That would be Privacy Beyond the EU, a working guide on data protection for businesses operating abroad. So I will leave the talk to Giacomo. Tell us why you really wanted Dr. Zipponi here today, Giacomo.
I just have to be honest, it represents to me a sort of Bible, and it could be a Bible for all the professional, just because it's the perfect tool for the practical approach that represents all the countries and all the schematic analysis that you can see in all the cases. So super practical and in this sort of guideline. So it's not just a theoretical book, but you can see the practical approach.
Well, that's exciting. So let's dive into this. But first, let me introduce to all of you Dr. Selina Zipponi. Welcome, Dr. Zipponi.
Nice to meet you and thank you. Good evening to all.
Good evening. So, before we start talking about your book, which is the real star of this show, let me ask you something about your life. So, you're an esteemed DPO, and we're all young professionals, and we would like to know what tricks you could reveal to all of us that would want to maybe follow your path. Tell us the tricks of the show.
Thank you. I have a theory that to be a good data protection officer or privacy manager or in general a professional in our field, you don't have only to study and deepen the subject, of course, data protection, but also invest in soft skills and project management skills. In fact, if you are an external DPO or an internal DPO, you will have to work within a company with other colleagues, with other departments such as HR, procurement, sales. Sometimes these departments are more focused on business correctly or than on rules, regulation. Therefore, one of the most difficult things is not to find a legal solution to a problem, but to explain to the other colleagues and share with them the importance of the issue, or to find with them the right balance and middle ground between different solutions and business needs and compliance needs. In addition, I think that having the best legal solution is not sufficient, but you also need to make it real and to implement it through a project. That's why project management skills are very important. Therefore, basically, I suggest to invest in soft skills and personal growth. So project management, communication, public speaking, and also how to handle conflict and negotiate solutions. It's a good skill.
Good skill. Well, then podcasting probably will be a good skill as well. Who knows?
Absolutely, absolutely.
We feel proud. I have a question from the board for you, Doctor. If your greatest admirer, please.
I will start saying that you are absolutely right. it's super hard for us understanding and also the communication with the stakeholders, since we have a variety of stakeholders. But let's talk about the core purpose of the book: helping professionals to navigate the multiple legal frameworks and create an harmonized policy that solves the everyday compliance challenges. What was the biggest obstacles that you encountered in this? And which was the country that represent for you the greatest challenges, also in terms of processes?
Okay, the aim of the book, as you said, is basically to help colleagues to find the right answers regarding legislation. And legislation, we're speaking about countries and legislation that are not well known sometimes. The aim is to support them in find the answer without starting without having them to start from the beginning to research sources and to understand the framework. So I cannot say that we found hindrances or obstacles in this process, but it was not an easy process because we started from researching the legislative text. And in some countries, there is not a single text, a specific and comprehensive data protection law, as it is in Europe, but there are different laws regulating also data protection aspects. Generally, laws in the field of information technology, information security. In addition, in some countries, the legislation is changing right now, and the context is complex. For example, it can be that in one country there was a proposal of law, but then was left apart or was slowed down for emerging of political problems. Then the second step was translating the legislative text. For example, in the book there is a chapter of related to Egypt, and the author is an Egyptian lawyer, so she could read and study the text in original language and study directly from the sources. In other countries, we didn't have this opportunity. So in other countries, we studied the official English translation of the legislation, if it was available. In other cases, it was not available, an official English translation, so we had to rely on a translation of the original text made by us or by tools. And this renders sometimes very difficult to study the text. Then the third step was reading and studying the whole text. Fourth step, understanding the text and the context. And this was difficult, especially in jurisdictions with a different approach from the GDPR. For example, we are used to speak in terms of controller processor and controller obligation, processor obligation, but there are countries such as Australia where you don't have this concept of controller or processor, and you just have app entity. And then finally, the last step was summarizing and extracting the most relevant and useful information for the resolution of the most frequent practical issues, making it easy to understand for the readers. For example, who read the book can find a chapter of just a few pages, easy to read, or a table at the end of the chapter, but this is for us the result and the summary and extract of a very accurate and comprehensive study. You asked me about the country. What is the country that represented the greatest challenge in the process? And I can tell this country is India, because at the time of writing the book, the legislation was very complex, and now also it is. It is in a transition phase because in India we have the first legislation, the Information Technology Act of 2000, that was intended to prevent informatic crimes, but regulated also some aspects of data processing. Then this act was subject to a lot of amendments and was amended and integrated with more specific regulation, such as the practices and procedures and sensitive personal data or information rules to 2011. And lastly, in 2023 was approved the first law on data protection, the first comprehensive law of data protection, the Digital Personal Data Protection Act. But this law is not yet in force and is expected to become applicable in the near future. So in light of all of these, the author had to illustrate the various legal institutions from a dual perspective, the current law and the future law. But the author was did it in a very good way, so we overcome this challenge. But I think India was very complex.
I just have to say thank you again, because you create a real source for all professional, but also a tool. But let's start with, for me, a huge topic that is also, I will say, perfect for the Halloween episode, because it's really scare me. So let's start with data breaches. Your book is a kind of revelation for every professional. You have included a table at the end of each chapter to sum up the main differences between EU and non-EU countries. From a perspective that you will be, what will be the major differences that you have seen between the EU country and the extra EU countries?
In terms of data breach, I think this situation is not so different from GDPR. So we basically have the same rule, so that we must notify the data breach if it is risky for the what we call data subjects. But I can make two practical examples of two differences that I appreciated in two legislation. So basically, the main concept, the main principle is the same. You must notify to the authority. But you can have, depending on the country and on the legislation, some relevant differences. For example, in Australia, the Australian federal legislation refers to the concept of eligible data breach. So, and the definition is similar to the definition, European definition, because it's when you have an unauthorized access or an unauthorized disclosure of an individual's personal information, and when you expect that serious harm to the personal sphere of the individual to whom the information relates would result from such a circumstance. But the main idea is that not all the data breaches must be notified, but only the eligible data breach. So when you have an hypothesis of data breach, when an app entity, because we have said before that in Australia we don't have controller and processor, but we just have app entity, so without distinguishing. In this case, if an app entity has the reason to believe that it has been impacted by data breach, must conduct an assessment to determine where an eligible data breach may be deemed to have occurred from the circumstance analyzed. And here the difference is the timing, because in Australia, the deadline to conduct such an assessment is 30 days from the moment in which the app entity becomes aware of the breach. So it's a very long term. In Europe, we know that GDPR states that you must notify as soon as possible and within 72 hours the breach. And generally, if you take a lot to analyze the breach, is not a good practice. In Australia, you have 30 days, you can analyze, you can conduct the assessment, and then we have the obligation to notify to the authority and also to notify to the individuals if they are impacted by the breach and there is a serious risk in their personal sphere. The other difference is that in the Privacy Act of Australia, you can rely on different exceptions. So we have a number of exceptions to exclude the data breach and to exclude the notification. So it's easier from some point of view to manage the data breach and not to notify and to manage it, resolving all the risks and all the negative impacts of the data breach. Another difference is that the authority has a lot of powers, including the power to request the app entity that has suffered the eligible data breach to engage an independent and adequately qualified external consultant to assist in the activity of implementation of the privacy compliance plan. So this when I have seen this rule, I thought that is quite a strange rule that an authority can impose the presence of consultants to an app entity. On the other hand, another example that is important for the different timing of the notification obligation is again India. In the current regulation, which we have said that will change in the future because the new comprehensive law will come into force. But for the moment, we have the information technology rules, the old rules. Here we don't have the data protection authority, but we have the CERT-in, which is the information security authority. So it's the authority that we must notify when we have a security incident, including data breaches, and is the information security authority. And here we have lists of incidents that we must notify, including data breaches in the meaning of GDPR. But the deadline is that you must notify to the CERT-in the incident within 6 hours of becoming aware of the incidents or its occurrence. So we have a very strict and short term to notify. The notification is easy. You can notify by email or by also by telephone in theory. You have a form in the website of the CERT-in that you can fill in with all the information where you flag the type of incident that you are notifying. And the CERT-in can impose some measure. The new regulation that will come into force in the future has a definition of data breach that is similar to the European one, but we don't have a strict term in this new regulation. We don't have a strict term to notify. The Act simply specify that the data fiduciary must inform the board as well as each data principal, which in the Indian legislation is the data subject of such a breach in the form and manner prescribed by the government. So in general, I think the principle is similar, but we have different timing, different forms of notification, reflecting the different legislation around the world.
Something that came up really to my mind about this really interesting comparative study that you did in your book is how the concept of sensitive personal data changes in the different legislation that you have analyzed.
Yes, this is a topic that is really interesting from my point of view, because in the book we analyzed 18 different countries, and in some countries there are things different from GDPR in terms of sensitive data, because, for example, I can take, for example, Australia is similar to GDPR. So health data, genetic data, biometric, criminal data. In New Zealand, for example, is not defined. So we don't have a clear and defined definition of sensitive data. There is a reference of sensitive data in the data breach discipline, and also the Commissioner of New Zealand has issued some guidelines where they are defined as the data with significant importance for the individual and the data that the individual would like to maintain private. The examples basically are similar to the GDPR, so health data, biometric, genetic, but it is a concept that must be defined case by case. So depends on the concrete case and context. And this is quite strange from our perspective. India, again, the current legislation, so the information technology legislation that is more focused on information security than on really data protection, something that is that was interesting for me is that sensitive data include also credit card number, bank account, financial information, so financial data that from our perspective is not common. In Thailand, Singapore is similar to the GDPR, but for example, in Singapore, we have the same of New Zealand, so a case-by-case consideration of sensitive data. In China, again, we find financial data, insurance data, localization data, and data pertaining to minors of 14 years. So in some countries, we have this specific inclusion of minors in the definition of sensitive data. South Africa, Emirates, UK, Switzerland, the same, similar to GDPR and including also criminal data. Saudi, something that was strange for me is that in the definition is written data relating to health or data where you can understand if one or both parents are unknown. So very specific provision. In LATAM, so Peru, Mexico, and this country of LATAM, we have a strong focus on intimate life and discrimination, so the risk of discrimination. Also in this case, we have the inclusion of financial data. A strange thing I found in Colombia, where when we are speaking about trade union, as in GDPR, where trade union is considered sensitive data, in Colombia is specified in the definition that is considered sensitive also to be part of a group to protect human rights. So being part of a group protecting human rights is sensitive data. So this was an interesting study for me to understand the difference that also reflect the different culture, maybe the importance that every legislation gives to sensitive data.
Thank you. Thank you, Dr. Zipponi. That was an amazing answer. And I think like what really has had an impact upon us listening, and I'm sure upon our listeners when they will get through this beautiful episode, is that by looking at something that's supposedly quite common between countries. So, I mean, all countries use IT, all countries have the need to kind of protect data because all users coming from each country have the need to see that data protected. Actually, in something that's like so universal, so uniting, you have found all the little differences that really belong to each single legal framework. And I think that will be beautiful for our listeners and has been beautiful for us to witness how uniqueness is still important despite the Internet of Things uniting us all in this digital world that we live in today. So thank you very much for this analysis, this roller coasters of informations. And before I let you go, I have to make one last plug for your book. So once again, for our Italian listeners, Privacy Extra UE, guida alla protezione dei dati per le imprese che operano all'estero. And hopefully for our international listeners, soon to become a book for them to read as well. But before I let you go, please, could you give us some suggestions apart from reading your book, which we have already bought, as you could have seen? Some books, some podcasts, TV series, something that would help people understand the role that your research is playing in the world right now.
I thought a lot what could be a good suggestion on this point, but I think, first of all, I think your podcast is obviously a fantastic tool that must be followed by young professionals because you are an example for them because you are a very good group of people studying, living abroad, speaking perfect English, being enthusiastic about studying and about the topic and the subject. So I think you are a very good example to all young professional and future DPOs and future privacy professionals. So this for sure. And
Here. Thank you. Thank you for that extra plug. Thank you so much.
and on the specific question about books, podcast, and movie, I think I will give you an unexpected, I think, answer because coming back to my first to the first question you asked me when I said that we must open our mind and not focus only on data protection. Again, in this question, I take the opportunity to say that I think, yes, we should deepen the subject, the topic, studying and also reading books on the topic and seeing, watching movies, podcasts on this topic. But in this specific case, where we are speaking about different countries that are not European countries, I think we should open our mind, seeing things from other perspective than data protection. So, like when you look at a painting, where you have to enjoy the details, but also you have to take a step back and see the whole picture, the whole painting. So I think that to understand data protection of non-European countries, maybe we could read books and watch movies about these countries, not about data protection, but about the country we are studying, to understand their culture and to see the whole picture. So, for example, it would be great if we have to study data protection in India, so the Indian legislation, we can watch a movie which is Leon, a movie dramatic, not very happy, but where you can see the country, India, and the culture. Or maybe you could listen to sacred traditional Indian music, or read an essay or a romance set there. And maybe also eat some naan bread, which is very good typical dish of Indian cuisine. So generally, I think it's good to have this setting of the country you're studying, and you can enjoy to study.
Well, that's a wonderful idea, especially because I guess that we all really love naan bread, especially when cooked in particularly good Indian restaurants around the world. So let me say then namaste to you. And it was a real pleasure and an honor. And I will say goodbye now. And goodbye to my friends who are still here, right, Giacomo's?
Bye, Rosie.
Totally right.
Thank you all, and goodbye.
Thank you.
Thank you. See you next time.